May it please the court. Good morning. My name is Joy Pearsall, Bar Counsel for the Florida Bar. Disbarment is required in this case for two reasons. The respondent sought to obtain a discharge in bankruptcy and walk away a millionaire. This court has said lack of candor and dishonesty cannot be tolerated by members of a profession that relies on the truthfulness of its members.
Let me ask you a question regarding a particular rule that Mr. Herman was found guilty of.
Yes, Your Honor.
Under the preamble to the rules of professional conduct, it says that the comment accompanying each rule explains and illustrates the meaning and purpose of the rule. Mr. Herman was charged and found guilty of Rule 4.3.3, which is candor towards the tribunal. In that comment to that rule, it specifically says, this rule governs the conduct of a lawyer who is representing a client in the proceeding of a tribunal. It also applies where the lawyer is representing a client in an ancillary proceeding conducted pursuant to the tribunal's adjudicative authority, such as a deposition. Was Mr. Herman representing a client in the bankruptcy proceeding?
No, he was not, Your Honor. He was the client.
So how can this rule then apply to Mr. Herman?
Mr. Herman is a lawyer, and he was a lawyer who filed for Chapter 7 bankruptcy.
Was he a lawyer representing himself? Was he pro se, or did he have a lawyer representing him?
He had counsel representing him, Your
Okay, so
Honor.
does this rule then apply under the comment section that this rule governs the conduct of a lawyer who is representing a client?
Under the wording representing a client, he was not representing a client, Your
Okay,
Honor.
thank
But
you.
he is a lawyer, and he did present a statement
I
to the
understand
court
that,
under
but
your
he is a
oath.
lawyer, but he was not representing himself before that tribunal, correct?
I agree with you, Your Honor.
Okay,
He was
thank
not.
you.
Can I ask you a question about the advice of counsel issue?
Yes.
Because it seems like the referee's findings here depended on a certain view of the law on that and how it applied, and it seems like the genesis of this idea that advice of counsel somehow, it shouldn't matter to the respondent's state of mind, originated from this Florida Bar versus St. Louis case. But in that case, the part of the case where we talked about that was where we were characterizing what the referee said. And then when we went to our own analysis, I guess because that issue wasn't part of the appeal, we never came back to it. And then St. Louis became precedent in Adorno, where it was cited, but in a very different context with, in that case, we said something like, Adorno was trying to blame others or that he was told by others something or other, but it didn't specifically analyze the advice of counsel thing. And I'm worried that this thing that's been called a precedent and that seems to have been a pretty significant part of the referee's reasoning isn't really something that our court actually held.
Well, Your Honor, the rulings in Adorno as well as St. Louis do speak to the advice of counsel. In this case, the referee's reasoning is well-founded based on the facts of this particular case. In addition to the referee relying on the ruling in St. Louis, which says that defense in bar cases, an attorney cannot rely on the advice of counsel.
Well, but his authority for that seems to be suspect, and it seems like, I understand that there were the two different sides had people who testified on this issue. It seemed like there was clear testimony from counsel to the respondent that he had advised the respondent that he didn't need to disclose this. And the way I read what the referee did was he felt like he didn't need to kind of wrestle with the significance of that because he cited to this St. Louis case and said, well, I think the referee's reasoning was even if that had been the legal advice that respondent got, that it wouldn't have mattered. And so if we take away that premise, where does that leave this?
Your Honor, I believe the referee went beyond that. He gave additional reasons in his report, and namely he spoke about that Mr. Herman signed his statements under oath. And the debtor in bankruptcy is responsible for his statements. And he swore under oath what was factual, and what he put in his statements was materially misrepresenting.
Right, but
so
but it still doesn't answer the question, which is, in most other areas in the state of Florida, under the law, anyone, a client, can rely on advice of counsel, and that is a defense. So how can it be that it is not a defense, advice of counsel, in a bar disciplinary proceeding?
Your Honor, if the plain reading of the bankruptcy schedules asked a specific question, and in this case, Mr. Herman was to swear under oath.
But you agree that bankruptcy is a specialized area of the law. In fact, there's a bankruptcy bar, and you have to be a member of the bankruptcy bar in order to practice before a bankruptcy judge.
I agree with that, Your Honor, but I would also say that if you're asked to tell the truth in a document, you should be truthful in that document.
I don't disagree with that, but when you read the cases that talk about whether a bonus or a fee is vested or discretionary, I mean, it's not so clear-cut to me that it would be a misrepresentation.
Well, Your Honor, in this case, all cases look at the different facts and circumstances. And in Mr. Herman's case, the bankruptcy court, as well as the referee, had testimony before them. And as part of the record in this case, there was testimony from the president of Mr. Herman's firm.
Yes, and let's
talked about his compensation.
Let's go to that, because that is important. Because
Yes,
Mr. Ponzoli did talk about that. And Mr. Ponzoli specifically said, who he was in charge of the compensation committee, that there's only 2 equity partners in the entire firm, and that the fees are fees earned by the law firm. And so whatever is distributed through our compensation process for performance bonus is solely the discretion of the compensation committee. And there should be no entitlement to that money because of one particular director until such time as the compensation committee sits and determines how the money is going to be dispersed. There is no entitlement. And Mr. Herman was not an equity partner. In fact, he was an at-will employee. Did he have a contract?
No, he did not have a contract,
And in
Your
fact,
Honor.
if you have a contract, then perhaps there would be an argument to be made, because you could say, I have a contract and I'm entitled to a $300,000 bonus, or I'm entitled to 10% of whatever I collect. But there was no contract at issue here.
Your Honor, but further into Mr. Ponzoli's testimony, Mr. Ponzoli's testimony, he also speaks about the compensation package for directors. 2/3 of the compensation for a director was their monthly salary. 1/3 of that compensation is performance-based. Mr.
Right.
Herman...
And there was testimony from various witnesses, not just Mr. Herman, but as in any law firm in the state of Florida, sometimes you get your full salary, sometimes you don't. Sometimes you get a bonus, and sometimes you do. So there was testimony that went both ways. In fact, Mr. Herman testified that there were years where he didn't get his full salary, and there were years where he didn't get a performance bonus. So again, the question here is it a vested interest or was it a discretionary interest? And if it was a discretionary interest, when he filed the petition, the only thing the trustee is entitled to do, he is only entitled to step into the shoes of the debtor at the moment the petition is filed. So anything that happens post-petition does not belong to the estate. If it's pre-petition, then it belongs to the estate.
Your Honor, the bar's position, as well as the findings of the bankruptcy court and the referee in this case, is that Mr. Herman's interest in the $10 million fee was vested based on his pre-petition work on
Counsel,
two particular cases.
How can you have, I'm struggling with the concept of how you can have a vested right in an undetermined amount. That's, I mean, maybe that such a thing exists, but I'm struggling with that.
Counsel,
Typically, when I think of a vested right, I think of something that you can say, I've got this specific right that's enforceable, or that will be enforceable under certain circumstances. And and here this is amorphous, what it was going to be. I mean, it's clear that Mr. Herman thought he was hoping he was going to get a lot of money. And he wanted, and it looks like to me from what is in this record, that it shows that he wanted more than he thought he was really, at least morally, entitled to more than he got. But how you can say that at the point when this was filed, that was vested, when it's totally indeterminate, I don't understand.
Well, counsel, that's not really what the referee found. What the referee, as I understand, and please correct me if I'm wrong, is that whether it's vested or not, I don't have to decide. Because this case is about a false statement that was made on a document made under oath. And that false statement related to whether he was reasonably anticipated to have income more than I think the 65 or 70,000 that he listed there. Isn't that what this is really about?
Your Honor, yes, it is.
We don't have to decide whether this was vested or not, or contingent or not. All we have to decide is whether there is competent, substantial evidence supporting the referee's finding that he knew in December that he was going to get more than he listed on that petition, right?
Yes, Your Honor.
But
Tell me what competent, substantial evidence there is in the record to support that finding.
The referee relied on the email communications between Mr. Herman
But
and
the email
president.
communications between Mr. Herman and Mr. Ponzoli, Mr. Herman was desperately trying to get an answer from Mr. Ponzoli as to what he was going to get. And after January, Mr. Ponzoli said, there is nothing, until we get the money, we're not going to talk about anything more. So the question was, even for the December, and by the way, this was the only time in the history of Tripp Scott, under the testimony of all the witnesses who testified, that there had ever been a distribution that was not solely at the end of the year. Because all the other distributions, if there was a distribution that year, was at the end of the year. So the question I have is, how do we know when he filed his petition in March, I believe. At that moment in time, he had no vested right to any distribution, because the distribution, as Mr. Ponzoli testified, and not just him, but other people from Tripp Scott, was solely discretionary, and it was based on what the compensation committee decided, whether or not he was going to be entitled to anything. Because really, frankly, at the end of the day, it was by the grace of the compensation committee as to whether he was going to get anything, a dime, 5 cents, $50,000, or $100,000, or $2 million. Where is the evidence that says that he knew when he filed that petition in March that he was entitled to receive anything other than his monthly salary?
Your Honor, again, I turn to the emails and the communication between Mr. Herman and Mr. Ponzoli, as well as Mr. Herman and Mr. McLaughlin. There's a specific email, Your Honor, which states a figure of $2 million that Mr. McLaughlin had thought about for Mr. Herman, and this was done, I believe, in January. This is prior to Mr. Herman filing his bankruptcy petition in February.
There was an expectation, but there's a difference. I'm sorry, Justice Muniz. Go ahead.
So but do we have to ourselves reach a judgment as to legally whether because really the question I don't think is vested or not vested. The question is, was he legally obligated to put down his expectation for this bonus on that form? And there's testimony from his lawyer that said, I looked at this and I advised him you do not have to disclose that. So do we have to say that the lawyer was wrong? I mean, the way I read the bar's expert was, he said, well, I think he should have disclosed it, and at the end of the day, I think you should err on the side of disclosing it when in doubt. But that would be a pretty flimsy basis for us to say that, he basically lied, and you're asking us to disbar him for that. I mean, it's easy to tell someone when in doubt, disclose, but I mean, you're asking us to uphold the finding that he lied by not disclosing it. Whether it was vested or not or whatever, he was given the legal advice, you do not have to disclose this.
Your Honor, the issue in this case is Mr. Herman's truthfulness and candidacy.
Was his answer to that question true?
Let's let her
Okay, I'm
answer
sorry.
his question.
The issue is Mr. Herman's candidness and truthfulness in his schedules, and Mr. Herman wasn't candid in his schedules. It says that he is supposed to describe his anticipated increase or decrease in income within the next 12 months, reasonably anticipated. The record before the referee was that Mr. Herman, through his own communications on his own words, expected a reward for his unprecedented, tremendous result. The emails say that it was going to be a win-win situation for all of us. He knew he was going to receive in a substantial
He didn't know.
amount of money.
How does one know? Because there's a difference under the case law, under the federal case law regarding bankruptcy. The question, and by the way, under state law applies as to whether or not his interest, his property interest, is vested or discretionary. And then obviously federal law applies for purposes of the interest under the federal bankruptcy law. The question is, what case law in Florida stands for the proposition that a bonus or a contingency fee where you have no contractual rights, you're an at-will employee, what does the law state? Or is there a case that says that you have a vested interest? Could he have sued Tripp Scott for unjust enrichment or breach of contract or anything if at December 31st at midnight or January 1st at midnight he got nothing? Could he have sued?
Your Honor, the bankruptcy court found that
Answer my
Mr.
question. Could he have sued under any cause of action for not receiving a percentage of that contingency fee?
Your Honor, based on those specific cases, the Home Depot and Security Mutual cases, the finding of the bankruptcy court is that Mr.
Answer my question.
Herman.
Is there a case in the state of Florida, because the state of Florida law controls the question about whether he has a property interest or not. The question I'm asking is there a case that stands for the proposition that you're an at-will employee and you have no contract, do you have an entitlement to that money? Could he have sued the law firm on January 1st for not paying him a bonus or a fee percentage of that amount?
Your Honor, yes, I believe, I'm going to look for the case if you give me a moment. I believe there was one that was referred to. As far as the date of January.
In the state of Florida, not anywhere, not elsewhere.
If he could have sued on the exact date of January 1st, Your Honor, that I am not sure of, but I believe the community case, I would have to check to see if it's a Florida case, so I don't want to speak before the court, address the idea of unjust enrichment. So if the court would give me a moment, Your Honor.
Isn't there a case from the Southern District of Florida, Rionda, and then there's another case that talks about, Rionda talks about Florida law, and it says there is no vested right in something or an unjust enrichment claim when you don't have a contractual obligation.
The Rionda case is a Florida case, Your Honor, and it does talk about unjust enrichment.
There clearly is no breach of contract. He wouldn't be entitled to sue under a breach of contract if he had not received any amount, any percentage of the $10 million, correct?
Okay,
There was
we're way in overtime here.
Oh, okay, sorry.
So, Justice Lawson had a question. I want to give him an opportunity to ask his question.
The question was his answer untrue? The question was, what do you anticipate getting? The answer was, I do get a bonus, and this is the range it's been in previous years. Was that untrue?
The answer was not truthful, Your Honor. It wasn't candid.
What was untruthful about the answer itself?
Because it says, what do you anticipate to reasonably get as an increase or decrease?
So it was a non-answer. He didn't answer the question they asked. He gave them different information.
Yes, yes, Your Honor, within the next 12 months. So from that time forward.
That could be construed as misleading because you didn't answer the question. You gave an answer that was excluded the response, which I think the evidence would support a finding that he did reasonably anticipate getting millions of dollars, right?
Yes, Your Honor.
So he left that out.
Yes, Your Honor, the record does
And the question that I'm concerned with is so that omission, material omission, is it a different disciplinary case if that anticipated bonus, he had no right to it and it wasn't an asset of the estate so that they really shouldn't have been asking for it, as opposed to the case where that's an asset of the state, so by omitting that, he's omitting something that would potentially defraud creditors? Are those two different disciplinary matters in terms of the proper sanction?
Your Honor, in this case, because the answer was not candid and bankruptcy rewards the honest debtor, the misrepresentation, which was material in this case, requires
Well,
a
I mean, I guess
severe
that's the
sanction.
question. Is it material if the lawyer's advice was correct, that this is not an asset of the state, it's not something the law requires you to disclose, it's not something that they have a right to? I mean, it's clearly, I mean, even if you assume even if it is an omission, and it's material in the sense that the question asks for the information, but is it a different discipline on those two scenarios?
Your Honor,
Should it be?
Your Honor, being untruthful in a sworn document before a bankruptcy court, it wasn't candid. It wasn't an answer that was required. On that same document, Schedule I, Mr. Herman put that he worked at the same firm for 30 years.
You've
So
answered my
putting
question. Thank you.
Thank you, Your Honor. Thank you very much. I'll reserve the rest of my time if I have any. If I have any.
The time you had is long, long, long.
Okay, well,
I mean,
thank
it's
you,
like
Your Honor.
You're
Thank
6
you.
minutes over, so, but I understand, the court facilitated that, so, sorry.
May it please the Court, Chief Justice, Justices of the Florida Supreme Court. I'm going to begin by answering some of the questions you asked, because I see where you're going. Candidly, I'm pleased that we're here, and I have no idea why we were here until now. I get it, and I'll try to stay away from those issues that you've not raised, but I would like to say something to begin with that I think is critical. We know now for sure that what Peter Herman put on his schedules was the truth. We know that for sure. And the reason we know that is because almost the entire bankruptcy order, which is what the bar hitched its wagon to from the very beginning, was based on Schedule B. Schedule B requires a decision between vested and discretionary. CIB, the creditor, took the position in the bankruptcy court and won, stating that it's vested.
Counsel, for me, and I can only speak for myself, there is a statement made that Mr. Herman reasonably anticipated an increase in his income of putting what in prior years was, I think, $65,000 or so.
65 to 70.
Okay. That's not truthful.
I haven't gotten it yet. I'll get there now, and it's in my notes. You were first.
You got to
on my
get
notes.
there, because
Let me-
I'm with you until there.
Okay. Well, that was pretty quick. Tying everything together, let me begin with this. Mr. Herman was not a lawyer in those proceedings representing a client. That's been noted.
And I think
So
Justice
if
Legault has
I-
a great point with that.
So advice of counsel does matter. Now, the question for you all to decide in your secret conclave back there, and when the smoke comes out, we'll know what's going to happen, does that affect whether he lied, meaning knowingly made a false statement, or if I can finish.
But counsel, our question is different than that. It is, because at this point, we're on an appellate panel dealing with a referee that has made findings of fact. So the question is, is there competent substantial evidence in the record to support the finding that it was an intentionally false statement?
No. No, and the reasons are several. Number one, you've got a guy going into a bankruptcy that's embarrassing the heck out of him. He knows that what he has to do now, based on the state court proceedings that began, they're going to start taking his furniture and his jewelry and his house and everything he and his wife own.
But counsel, haven't we said...
Can I finish, Judge?
Counsel, haven't we said under the case law that a referee and us are entitled to rely on a prior finding by another court?
Yes, sir.
And didn't the bankruptcy court here find that there was an intentionally misleading statement?
But
Yes.
I'm sorry, but the bankruptcy judge
Did
so by not...
Can I get an answer?
We're going to let him answer Justice Luck's question.
Thank you.
I didn't hear the question. I heard statements, I didn't hear a question.
I will repeat the question. Didn't the bankruptcy court find, you had previously said yes, that we and the referee are allowed to rely on a trial court, on an order finding, and that was entered into evidence in this case. Didn't the bankruptcy court find that there was a false statement here, intentional false statement?
He did without substantial competent evidence, and that answers your full question, not the half of the question. Yes, he made that finding, but you have to remember, and this has got to be the critical part of this, the bankruptcy judge made that determination not allowing in, and it wasn't his fault, it wasn't pled, not allowing in the advice of counsel defense, not allowing in and never hearing from until the contempt proceeding at the end, also critical, I'll get to it in a moment, but never hearing why Peter did what he did.
Mr. Rothman,
But
Mr. Rothman, but isn't it true also that the bankruptcy judge, Judge Jones, in making that finding, there was no competent substantial evidence because he completely disregarded the actual evidence and testimony of 3 witnesses who testified that that money was discretionary because it did not vest until the compensation committee decided and determined who was going to get what and how much, if any.
And the very beginning of your question was?
Did the bankruptcy judge, when he made that finding, he did so by completely disregarding the witnesses who testified?
Yeah, there were a total of 7 testimonies in the bankruptcy case and the bar case relating to that very issue. It went unrebutted, unchallenged, and just stood there as this harbinger of this evil that Peter had concocted.
May I ask you another question? In March, correct me if I'm wrong, March of 2012 is when Mr.
When the
Herman,
schedules were filed.
When the schedule was filed. In March of 2012, the $10 million had not yet hit Tripp Scott. Only a part of it had hit, but not the full $10 million.
That's correct, but I need to correct one thing. That doesn't matter under bankruptcy law, and I didn't know this because I'm just a criminal defense lawyer and bar defense lawyer. What matters is the February 18th date when the petition is filed.
No, I understand that, but at the time that the petition is filed, actually Tripp Scott has no money. They've received no monies, correct?
That's correct.
And then my understanding is that the first distribution, or not even distribution, the first hit that comes in from one of the cases is in March, and at that point in time, Ponzoli tells Herman there's not going to be any distribution. In fact, nobody expected any distribution because Tripp Scott did not have a history of having any distributions up until a yearly distribution, if any.
That's accurate.
Let me refer you to the findings of the referee in paragraphs 94 and 95, particularly 95. The referee notes that at the time the bankruptcy schedules were filed, that your client had received $2.7 million bonus.
I'm sorry, what paragraph are you on?
95. At the time these bankruptcy schedules were filed, had your client received $2.7 million?
No, sir. No. At the time the petition was filed, he had received nothing, and the law firm had received nothing, and there was still ongoing litigation as to whether the law firm was going to get any or all or part of that money.
Right.
That was the 2.7 was his expected fee to be received?
No, that's what eventually was paid, which was put in trust at the end after Mr. Herman, well, at that point he amended his schedules, which was noted by the referee, but that's much later on down the line.
There's in the second sentence of that paragraph, this says, the non-disclosure, it said, respondent knew he was well positioned to actually receive a multi-million-dollar bonus from the $10 million fee. This is especially true since just a few weeks prior to the respondent filing the schedules and SOFA, Tripp Scott had actually received that fee. Is that true or false?
That's incorrect.
It's incorrect.
As far as the referee's findings, though, to the extent that they may have been premised on a misunderstanding about the advice of counsel issue because of misreading our cases, and I'm not sure what the legally, what the law should be, but it seems like the authority for that is not what it was purported to be. Does that undermine, the validity of the findings? I mean, if the referee essentially didn't get into his state of mind as potentially affected by the advice of counsel, then it seems like that.
And that's the result of the referee deciding, and he wrote it point blank, advice of counsel is not a defense in a bar case. Period, end of discussion, and it never was discussed again. It never was raised again.
Didn't he, though, didn't he rely on two other justifications in
Yes, sir.
rejecting? So it's not that he didn't consider advice of counsel, it's that he may have made a legal mistake. But he also said, counsel, didn't he also say in the referee's order that your client independently looked at the case law that his lawyer had done and made an independent determination on the legal issue?
Which supported the referee took that as an aggravating factor, that my client read the cases that the lawyer gave him to show him why he decided that the Schedule B required no information because it was discretionary. Peter read those cases. If your honors want to read those cases and see it, it supported the opinion of the lawyer. So it's not an aggravating factor, and it's not just a mitigating factor. It's a defense.
But doesn't it go to the advice of counsel? In other words, what I understand the referee to be saying is, it's legal. I legally can't consider it, and even so, he didn't rely on advice of counsel because he made an independent legal determination.
You're inferring by that question that a person, whether it's a lawyer or non-lawyer, should be punished for following up on his or her lawyer. No, it doesn't matter, but if it does matter, it is to Peter's benefit. Because when he read the cases, including Rianda, as I recall, decided by a fantastic district court judge in Miami, including that case, it demonstrated to him it was not vested. Again, going to Schedule B, you're referring in your questions earlier, which I'm now finally getting to, Schedule I. Schedule I's simple question was, do you expect to get an increase or a decrease in the coming year? Answer, yes.
Well, no,
Then in
that's not-
parentheses.
No, I've got it here. I'm reading it. And what it says, it's a little hard to read because the printer is blurry, what printed out, but it, describe any increase or decrease in income reasonably anticipated to occur within the next year following the filing of this document. And then it says annual performance bonus, parentheses, historically 65,000 to 70,000, close parentheses. Now, I don't see that there's any way you can read that without saying that there's an assertion there that he reasonably anticipated that an annual performance bonus that would be in line with what he had historically received. And I also have trouble understanding how that was a truthful statement of fact. Leave aside the law, whether this is part of the estate, I understand that's a different issue. But I'm having a hard time understanding how anybody could think that, given the facts that we see here, was a truthful statement. Now, disabuse me of my perception of that if I'm wrong.
I'll try. There's a few things at play here. Number one, you can't pull a statement just out of the air or out of a document without knowing the context. The context of this is Peter Herman had taken on two massive cases, one of them very late in time, and one on behalf of two clients, two of his character witnesses. The clients made millions and millions of dollars. Mr. Herman was not going to make millions and millions of dollars, but he got a verdict in two cases, and then with their appeals, and then the publications that talked about what a great job Peter did. It was David versus Goliath. It was well known, well publicized. Step forward. He's under the embarrassment of
So that's saying that, well, because everybody knew about this, I didn't have to answer this.
No, we're talking about state of mind. Justice Kennedy, we're talking about state of mind. That's what this is really about. If something is a lie, it has to be in your mind. If you are crazy and you think it's the truth, is it a lie? No, it's not right, but it's not a lie.
I'm sorry to interrupt you, though. Is there in the record, did your client's lawyer testify that he gave advice as to answering that specific question? Not the B, but the I.
Specifically, both Peter and his lawyer testified that what happened was his lawyer said, give me all your documents, give me all your records, and we, as our courtesy in these types of cases, we fill out the paperwork. In the paperwork was his prior history, his tax returns, everything. The lawyer filled it out, and then the lawyer said, Peter, tell me, and this is his testimony, tell me, ballpark, what you normally get as a bonus if you get a bonus.
Did the record, though, did the lawyer give advice knowing about the possibility of getting money for these cases?
It's
did he
paragraph
testify
9.
about I?
Yes, and what the evidence proved, both in this case, which didn't go to the bankruptcy judge, and through depositions, is that not only did the lawyer, the bankruptcy lawyer, know it.
Was this his testimony?
He investigated
I advised Mr. Herman that on Schedule I, he should disclose that he anticipated receiving an annual bonus, performance bonus, in an amount that was estimated based upon past year bonuses. That's what he testified.
And the same thing that Peter testified to, not in the bankruptcy case because...
And was there anything on the other side suggesting that the advice was a sham, or that there was, I mean, obviously people think that it was, incorrect advice.
It was never challenged, and there was not a single fact witness other than a trustee who was called by the bar. And in answering to your question also, Justice Luck, the trustee said, upon reviewing the schedules, he doesn't really pay much attention to I. It's sort of a throwaway. But had he looked at it, it would have put him on notice that Peter was getting a bonus, which would have been one of the discussions he had with the firm. Standard operating procedure, which of course Mr. Houston, the lawyer for Peter, knew and told Peter that this is what's going to happen in this proceeding. Peter would have to be either insane or a moron to think that no one was going to know about these $25 million $50 million in judgments from which his firm was going to get about $10 million.
My understanding is that Mr. Houston also, in his affidavit, said, Mr. Herman, I gave him advice that he did not have a vested right to a bonus, and therefore any potential discretionary bonus would not be considered his property, but rather the property of Tripp Scott, until such time as a bonus was actually awarded. That was his advice from his counsel.
Yes, and it was uncontroverted and unchallenged. And Mr. Herman pointed out correctly in response to your statement and question, it was absolutely certain that the amount of any bonus would be uncertain, if at all, being given within discretion, unrefuted, undisputed by the testimony. The findings, we're not here to retry the bankruptcy case. I'm not going to do that. But in front of the referee, it lacks sufficient evidence to prove by clear and convincing evidence.
Did the bar present any evidence that Mr. Herman had an actual deal with Tripp Scott that he was to receive X amount of money?
No, because that would be impossible since it didn't happen. But no, there was no such evidence.
Counsel, you're in overtime now.
Could I make my
Sure,
closing statement?
but since the bar got a lot of overtime, I'll give you a little more time, but, try to sum up.
My client doesn't want me to talk about sanctions because he believes he's innocent. So I'm going to listen to him, and I'm not going to do that. But what I am going to tell you is that in this case, it's without hyperbole that I say that Mr. Herman's discipline case is factually rare, if not unique. Bankruptcy law is a hyper-technical, almost obscure practice area. Even experienced lawyers don't know about bankruptcy unless they've been involved in bankruptcy, and my guess is it would be the same for judges. And when you are inexperienced as to the law, what do? You hire a lawyer. Mr. Houston, as he testified, was a bankruptcy lawyer. His father was a bankruptcy judge, and Peter knew him for many years, so he trusted him. He went to him. He had nothing at all during the representation until it hit the fan at the end in the contempt proceeding, where the judge called both Mr. Herman and his lawyer before him to discover whether both or one was in contempt for the way that Mr. Herman paid his lawyer's fee. For the first time in the bankruptcy case, Mr. Houston testified because he was called as a witness by Mr. Pugac, who now represents Peter in that hearing and thereafter. And in that hearing, Mr. Herman said the same thing he said in this case. I gave him the advice. He said he was a babe in the woods as it related to bankruptcy cases. He followed my advice. After that, the judge who had denied the discharge, the same judge, found Peter not guilty of contempt, Mr. Houston guilty of contempt, and stated as to why he found Peter Herman not guilty. Very simply, he was the unwitting client relying upon the advice of his lawyer. If he's not guilty of that contempt for that reason, he's not guilty of a law violation. Thank you.
All right, we thank you both for your arguments, and the court will now be in recess for about 10 minutes. All rise.